Good afternoon, everyone, and welcome to the Pennsylvania Human Relations Commission's Fair Housing and Power Hour session. We will get started in just a moment. All right, it looks like we have everyone in through the waiting room, so we'll go ahead and get started. Well, welcome to the Pennsylvania Human Relations Commission's Fair Housing and Power Hour session for June on housing and assistance animals. My name is Brittany Mellinger, and I'm the Director of Fair Housing and Commercial Property for the Pennsylvania Human Relations Commission. And if you've been following along with our series this year, we've had a series of guest speakers coming in to talk about various topics surrounding fair housing. We are taking a quick break for this session to discuss the topic of assistance animals. So there has been a lot of conversations and questions about assistance animals in Pennsylvania, especially in light of federal actions. So we wanted to dedicate our discussion this afternoon to assistance animals so that housing providers, community members, housing advocates have a clear understanding of rights and responsibilities in this area. Before we get started, I do want to draw your attention to the notice in the chat. So the Wiretap Act, it is against the law in Pennsylvania to record oral conversations without the permission of the folks involved in most circumstances and consent to recording. So this session is being recorded for training and/or record-keeping purposes. By participating in this session, you are consenting to the recording, retention, and use of this session. At any time, if you have a comment or a question, please feel free to place that in the chat and we will respond to you as soon as possible. If you would like to ask your question or to comment verbally, please note that by doing so, you are consenting to the recording, retention, and use of your statements recorded as part of the session. If you have any questions, please let us know. All right. And everyone has the right to fair housing in Pennsylvania. We know that housing is so fundamental to all the things that that we need for strong communities, strong families, and the resources that we all need to thrive. So the opportunity to have fair housing free from discrimination is incredibly important, and we put a really strong emphasis on that at PHRC. I do want to also provide this engagement acknowledgement and a disclaimer that information materials and/or technical assistance are intended solely as informal guidance and are neither a determination of your legal rights or responsibilities under the PHRA and/or applicable federal laws, nor binding on any agency with enforcement responsibility under those same laws. So I'm not an attorney. I cannot provide you any legal guidance. This is an informational session about fair housing rights and responsibilities this afternoon. To give you an idea on where we're headed in the next hour, we will start with a brief introduction about the PHRC for folks who are unfamiliar with our agency. We will discuss our fair housing laws, protected classes, and discriminatory practices before really getting into the heart of our matter today. So reasonable accommodations and modifications for individuals with disabilities. We'll talk about how to navigate these assistance animals requests, both from the perspective of folks who are seeking an assistance animal to meet their disability-related needs, as well as housing providers who are seeking to accommodate these requests appropriately. We'll close out with a discussion about the fair housing complaint process. And throughout the course of today's presentation, we'll be answering any fair housing questions that you have. So please feel free to put any questions, any comments, any insights that you'd like in the chat. We'll keep an eye on that and we'll attempt to respond to as much during the course of the presentation today, but we'll save some time at the end to answer any questions as well. So I do see a lot of my colleagues on the session today. So this is a review for most of you, but for folks who are unfamiliar with our agency, the Pennsylvania Human Relations Commission is the leading civil rights enforcement agency in Pennsylvania. We were established in 1955, and we exist to ensure that Pennsylvanians can live, work, and learn free from unlawful discrimination. So we do that through a two-part mission. We enforce Pennsylvania's non-discrimination laws, which include both the Pennsylvania Human Relations Act as well as the Pennsylvania Fair Educational Opportunities Act. So when folks believe that they've experienced unlawful discrimination, they can contact our agency and have their incident investigated to see if there was a violation of our state law. But we don't just sit back and wait for complaints to come in. We are actively in communities working to promote equal opportunity for all in Pennsylvania. So we do that through trainings like this one, through events, through seminars, through workshops. We also have active outreach coordinators that are out in communities throughout Pennsylvania, and advisory councils, which are groups of individuals who volunteer to ensure that our resources and information and services reach communities on the ground, and that PHRC is hearing about concerns in local communities as well. So if you are interested in getting involved with that, you can find information on our website. We do serve the entire state of Pennsylvania through 3 regional offices. The western part of the state in that dark blue is served by our Pittsburgh regional office. The light blue, the central part of the state, that's served by our Harrisburg regional office. And that medium blue in the eastern part of the state, those counties are served by our Philadelphia regional office. We also have a central office, which is located in Harrisburg as well. I mentioned our 2 laws that the PHRC enforces just a moment ago, and I want to let you know what those cover. So our focus is, of course, housing today, but under the Pennsylvania Human Relations Act, the PHRA, it also covers employment, commercial properties, so properties where businesses are located or land that could be developed into businesses. Public accommodations, so public businesses, restaurants, services, local governments, as well as primary and secondary education up through high school. That coverage is extended into post-secondary education through the Pennsylvania Fair Educational Opportunities Act. So that would include colleges, trade schools, and technical schools. If you'd like information about any of the other areas of our protections, you can find that on our website as well. So let's talk about our fair housing laws. So we talk about fair housing as having 2 goals. First off, ending housing discrimination, making sure that no one is kept out of housing opportunities because of their protected class, whether that's a discriminatory action or a policy. But fair housing goes beyond that. Goal number 2 is promoting diverse, inclusive communities. That's known as affirmatively furthering fair housing. So acknowledging that our country has had a long history of housing, and in the past we've had policies and practices and laws. So these things that have been implemented by governments, by private actors, by private industry, all working together to shape what our housing looks like, and that's resulted in some pretty significant housing inequalities. So there's a lot of work that we all need to do to be promoting diverse, inclusive communities, making sure that everyone has access and opportunity to housing. What do our fair housing laws cover? Well, they cover the sale and rental of housing, as well as housing-related transactions. Sale and rental are relatively straightforward, but housing-related transactions might not be as intuitive. So that could be the ability to get a fair appraisal for the value of your home, the ability to get insurance on your home free from discrimination, the ability to secure a mortgage. Any of these industries surrounding access to housing are responsible for knowing and abiding by our fair housing laws as well. The types of housing that are covered under our fair housing laws are broad. So it's anything from your apartments to single family homes, manufactured housing communities, condominiums, public housing complexes, nursing homes, dormitories, and more. Even some types of shelters are covered by our fair housing laws. Likewise, the folks that are responsible for knowing and abiding by our fair housing laws are really broad as well. It's really anyone that's making decisions in housing. So your property owners, your managers, your homeowners associations, your HOAs, your municipal officials, lenders, realtors, and others. We'll be talking about two different discrimination theories today, so two different types of discrimination. The first one is disparate treatment. That's treatment that directly discriminates against a member of a protected class. So it's what a lot of folks think about when they think about housing discrimination. Someone was denied housing or offered different terms and conditions based on their race, their disability, their sex, etc. But disparate impact is also discrimination. So that's a policy that's neutral on its face, but it has that disproportionate or disparate impact on a member of a protected class. So we have three different layers of fair housing laws, which can make it complex to understand fair housing rights and responsibilities. At the federal level, there's our Fair Housing Act of 1968. There's also Section 504 of the Rehabilitation Act of 1973, which applies to federally assisted housing and programs, and the Americans with Disabilities Act of 1990, which extends additional protections to individuals with disabilities, both in housing as well as in public spaces. At the state level, it's the Pennsylvania Human Relations Act, the PHRA, that forms the basis for our protections, as I mentioned just a few minutes ago. And then at the local level, there may be a local ordinance, depending on where you live or work in the state, that provides even further protections. So an example of a local ordinance that wouldn't be available at the federal or the state level would be source of income protections. So there are some areas in Pennsylvania, specifically looking at Philadelphia, at State College, at Lehigh County, as well as in Erie, that have source of income protections that ensure that someone can't be denied housing based on what they're using to pay their rent, whether that's child support, alimony, Section 8 voucher, earned employment. And there are protections in place for that. But those aren't statewide and those aren't federal. So we're going to be focusing most of our attention on our state protections today, but I will refer to our federal and our local protections as well. And that map on the screen there that you can see, it's a little bit small, but there's a link there where you can go to an interactive map there, and that shows in the green where there are local human relations ordinances throughout the state. There are some differences in jurisdiction when we're looking at our federal and our state protections. So under the Federal Fair Housing Act, housing providers with 4 or more properties need to comply with our fair housing laws unless they publicly advertise their vacancies or receive federal funding. So if they're doing advertisements, there can never be discriminatory advertisements, and recipients of federal funding can't discriminate in their housing and housing programs. But smaller landlords would not need to comply with our federal laws, but they aren't exempt from our state laws. So under the Pennsylvania Human Relations Act, a housing provider with 1 or more properties needs to comply. So it's important for all housing providers to be fully aware of their fair housing responsibilities. If someone wishes to file a fair housing complaint, that timeline looks different, whether you're filing with our agency or whether you're filing with the U.S. Department of Housing and Urban Development. HUD. So HUD enforces the Fair Housing Act, and if you wish to file a complaint with that agency, you have up to a year, 365 days, to be able to file that complaint. If you're filing with our agency under the Pennsylvania Human Relations Act, you have 180 days from the date of the last harm, or about 6 months. Next, I'd like to take a look at our protected classes. So you can see on the left-hand side of the screen here are protections under the Fair Housing Act, which are race, color, national origin, familial status, religion, sex, and disability. You can see on the right-hand side of the screen that our state protections are even more expansive than federal protections. So we have many of similar ones. So we've got race, color, national origin, familial status, religious creed, which is very similar to religion, sex and disability. We also add on age 40 and above, ancestry, as well as the use, handling, or training of support animals for disability. I'm going to go into some of these protected classes in a little more detail. So under familial status, that includes families with children under the age of 18 living with parents or legal custodians. It includes people who are pregnant, as well as people who are securing custody of children under the age of 18, which includes both foster children and biological children. There is an exemption for certain types of senior communities that are covered by the Housing for Older Persons Act. So there are some 55 and over and 62 and over communities that can restrict families with children because they are designed for older adults. I want to talk briefly about race as a protected class under our state protections, and they do include Crown Act protections, which is specified as traits associated with race, including hair textures or protective hairstyles. So we first instituted these protections through regulations in 2023, but they were signed into law this year, and you can find more information about that on our website. I also want to provide some clarification about sex as a protected class under the Pennsylvania Human Relations Act. So you didn't see LGBTQ, sexual orientation, gender identity on any of the lists of protected classes that we showed just a minute ago, but we did finalize regulations in 2023 that established that the term sex may refer to pregnancy status, childbirth status, breastfeeding status, sex assigned at birth, gender identity or expression, affectional or sexual orientation, as well as differences in sex development. So we use these regulations as we accept complaints, conduct investigations, and adjudicate cases. So if someone believes that they were denied housing or faced housing discrimination because of their sexual orientation, their gender identity, their gender expression, any of these factors, they can file that complaint with our agency under the protected class of sex. This is not the same at the federal level. Although it was in the past, currently HUD is not accepting these types of complaints under the protected class of sex, but individuals do have the right to file those with the Pennsylvania Human Relations Commission. And the last protected class that I want to cover in more detail is disability. So this is the one that we're focusing on today in our discussion about assistance animals. So it's defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. So that could be caring for oneself, walking, seeing, hearing, speaking, breathing, learning, or working. It's not an exhaustive list. These are some examples of how someone's disability may impact their daily life. Our fair housing laws protect those who have a disability, those who have a history of a disability, as well as those who are regarded as having a disability. So someone can experience housing discrimination based on their actual disability, but they can also experience discrimination based on someone's prior knowledge of their medical history or how they are being perceived, and they have the right to file a complaint if they believe they have received unfair treatment on that basis. Some key exemptions here are individuals who are currently using illegal drugs or controlled substances. They would be exempted from disability-related protections. That does not include those who are in active recovery. That's folks who are currently using these substances. Individuals who pose a direct threat to the health and safety of others would also be exempt from disability-related protections. And to give you an idea of what housing discrimination might look like, it could be anything from discriminatory statements in conversations or in advertising, discriminatory inquiries into someone's household status, into age, children, race, etc. Someone's applying for a mortgage or to rent a home, steering to a specific type of housing, to a specific neighborhood, to a specific floor on the basis of someone's identity. Refusal to sell, lease, or finance housing, an unfair appraisal of the value of your home based on your protected class, predatory lending, unfair terms and conditions in lending based on protected class, as well as discriminating in the terms or conditions of housing, so unfair lease terms and policies. Unequally providing services and facilities based on someone's protected class, as well as sexual harassment or discriminatory actions. But today our focus is going to be specifically on refusal to provide reasonable accommodations and modifications for individuals with disabilities, since that's where assistance animals fall under. So let's talk about disability-related protections. So in March, we released our most recent annual report, which covered 2024 to 2025. And disability-related complaints were the most common type of fair housing complaint that were filed with our agency. This is consistent with what other agencies report statewide, as well as with the national statistics. And it's pretty consistent year after year. To ground our conversation, I want to share some stats about individuals with disabilities who live in Pennsylvania. So over a quarter of Pennsylvanians, 27.7% in 2022, had a disability. So almost 3 million individuals. So this impacts a lot of people's daily lives. And these disabilities are not all the same. So there's cognitive disabilities, mobility disabilities, independent living disabilities, hearing, vision, and self-care are some of the main categories of disabilities. You can see there's varying percentages of folks who have these types of disabilities, but I just want to stress that this is something that impacts so many individuals who are navigating housing situations. So individuals with disabilities do have the right to request a reasonable modification or accommodation. So as I get into the definitions here, I'd like to encourage folks to open up their chat boxes and let me know some examples of reasonable modifications and accommodations that might be requested in housing settings. So as you are pulling up those chat boxes and offering some examples of reasonable accommodation and modification requests, I'll go through the content on this slide. So a reasonable modification, that's a structural change that's made to the premises. So that's when you're changing the physical structure of the premises. And a reasonable accommodation is when you're making a change, exception, or an adjustment to a rule, a policy, a practice, or a service. All right, does anyone have any examples of accommodations? Yes, a reasonable accommodation request might be waiving a pet deposit for a support animal. Absolutely, and very germane to our topic today. All right, we'll go into some more descriptions, but please feel free to enter any suggestions or thoughts that you might have on examples of reasonable accommodations or modifications. A modification could be requesting a ramp in front of a house. Yes, if someone has a mobility disability, they might use a wheelchair and need a ramp, or transition ramps for doorways. And an accommodation could be allowing a dog, regardless of breed or size, for a support animal. Absolutely. Thank you so much for offering that comment. So it is discriminatory to refuse to allow a person with a disability permission to modify and pay for changes that enable them to use a facility. So to state that a little bit more clearly, it's the tenant's responsibility to make the request, and then the housing provider's responsibility is to approve that request. If it's a private landlord that doesn't receive federal funding, then it's the tenant's responsibility to pay for that. If this is a housing complex where they do receive federal funds, if it's through a public housing authority, if it's subsidized housing, then the tenant's responsibility is to make that request, and then the housing provider is responsible to approve it if it's reasonable and to pay for that change. So there's that difference based on whether the housing is covered by Section 504 of the Rehabilitation Act of 1973. And a housing provider or manager may require the resident to restore the interior back to the original condition at the end of tenancy, minus normal wear and tear. So examples of reasonable modifications, installing grab bars in a bathroom or constructing a ramp for an individual in a wheelchair. Looking at reasonable accommodations, it's discriminatory to refuse to make reasonable accommodations in rules, policies, practices, or services that are necessary to afford equal opportunity for a person with a disability to use and enjoy a housing accommodation. So that could look like allowing a person who receives disability income to pay their rent on a different date than other tenants because they're receiving this income on the basis of their disability. It could look like reserving parking for an individual with a disability who needs that parking reserved in order to access their housing. It could look like an individual requesting to have a service animal if there's a no pet policy, or even a request to adjust zoning policies that are needed to allow a group home for individuals with disabilities to live out in the community. So how should these reasonable accommodation requests be handled? It's important to note that these requests can be made at any point in the tenancy. It can be when someone is first inquiring about a rental unit. It can be when they're signing their lease after they've moved in, 10 years after they've moved in, because disability-related needs change over time. You never know what the next day is going to bring. Someone's chronic condition may change their needs over time, or there may be a drastic difference in someone's health and disability status. Reasonable accommodation requests can be made in writing, or they may be made verbally. So I strongly recommend that all of these requests be made in writing, just for clarity around when that request was made, what was requested, what that response is. It's helpful to have that paper trail. But if you're a housing provider, you should accept a verbal request as well. You can request follow-up documentation as appropriate, as we'll talk about in just a minute, but you should not immediately deny a request just because it's made verbally. The request does need to be reasonable and needs to be necessary for the resident to use and enjoy the property, and the housing provider or manager has the responsibility to treat residents who are making these requests fairly and to respond in a timely manner. I see some additional suggestions for modifications. So it could look like handrails, widened hallways, tactile signage, grab bars, stair lifts, accessible kitchens with lowered countertops and safe storage, and also contrast lighting for visually impaired individuals. Thanks so much for those examples. All right. So when a housing provider or a manager is presented with a reasonable accommodation request, they are seeking to establish two criteria. So first off, does the person seeking the accommodation fall under the protected class of disability? Do they have that one or more impacts to their activities of daily living? And do they have a disability-related need for the accommodation? Is there that clear connection between what they're asking and what their disability-related needs are? So if this is a reasonable request and you can establish both of these factors, so are they an individual with a disability? Do they have that disability-related need? What do you think? Do you think we should grant that request or should we deny that request? You can feel free to pop your thoughts in the chat. Should the request be granted or should it be denied? I see one individual says grant, and that is correct. That request should be granted. Now, there can be some documentation that's requested in order to verify that this is a legitimate request. So a housing provider or manager can ask for proof of need, but only if the disability is not observable. So for example, if someone is approaching a property manager in a wheelchair and is requesting a ramp to access their home that has some stairs, you can see very clearly what their disability-related need is, and you can also see that connection between their need to be able to access their home and the ramp. So there shouldn't be any further documentation that's being requested. But there are many times in which a disability is not observable, and a housing provider may not know that connection between their disability-related need and what they're requesting. So in that case, they can ask for verification. Oftentimes, that verification will take the form of a note of need. It can be from someone's primary care doctor. It can be from another licensed care professional that can attest to someone's disability-related need for their request. So it can be from a therapist, a psychiatrist, podiatrist, a licensed social worker. It really can vary. But if someone is a licensed professional and is attesting to this individual's disability and their disability-related need, then that should be sufficient. Some alternative documentation that could establish disability also includes a determination of disability from a governmental agency, receipt of disability benefits or services, as well as eligibility for housing assistance because of a disability. Now, this often begs the question, but you're talking a lot about reasonable accommodations, reasonable modifications, but what's reasonable and how do we think about this reasonableness? This assessment is on a case-by-case basis, but some factors that you can consider include the cost of the accommodation that's being requested, what the financial resources of the provider are, the benefits of the requested accommodation to the person that's making this request. How is this going to benefit this individual and help them to be able to live in their home, as well as the availability of alternatives to the accommodation that's being requested. There are some potential reasons for denial. So a denial can be made if the needed documentation isn't provided. So say someone makes a request for an assistance animal and it's a non-observable disability and they never come back with that note. That request can be denied until that documentation is provided. If the specific request would pose a direct threat to the health and safety of others on the property, that's another reason for denial. If that request would cause substantial physical damage to the property, that could be denied as well. If the request would pose an undue burden on the provider, looking specifically at their finances and their capacity, or if it would fundamentally alter the nature of their operations and the services that they provide. That's also reason for denial. But if that initial request needs to be denied, that's not the end of the conversation. That's an invitation to enter the interactive process. So engaging in conversation to see if there's any alternative ways that the housing provider can meet the needs of this individual with a disability. So you want to make sure that this conversation takes place in a timely manner. There's not extended delays without a response. So that way you can see how to meet the needs of a tenant. And it can take some negotiation, some conversations, some back and forth to determine an effective resolution. So this should be fully documented and saved in the housing provider's records and also sent to the tenant as well. So that way everyone has a full record of what was discussed and what was decided. As you're engaging in these conversations, you want to be really cautious not to ask intrusive things that would violate someone's right to medical privacy. So a housing provider may not ask questions about the nature or severity of the disability, cannot ask questions that lead the tenant to disclose privileged medical information, cannot ask to see medical records, and may not ask to see if the tenant is able to live independently. So that is a quick overview of the general process. So let's get into the nitty-gritty around service and support animals. We're going to start off with some terminology. So assistance animals is your broad umbrella term. That includes both service animals as well as emotional support animals. They are sometimes called ESAs, and they are sometimes referred to as support animals. Both service animals and ESAs are covered under Pennsylvania Fair Housing Protections. You may be aware of a memo that HUD released last month that provides information about the ways that their agency is enforcing federal protections around assistance animals. That does not have bearing on PA laws and protections and the ways that Pennsylvania looks at service and support animals. I want to note that therapy animals are a separate third category of animals. They are for use in therapeutic settings and they are not covered by fair housing protections. Likewise, pets are not covered by fair housing protections. Let's talk about service animals first. So a service animal is generally trained to perform a specific task. So a service animal will generally support someone with a physical disability, which may or may not be obvious. They can also support individuals with mental health needs and developmental disabilities as well. A service animal is typically a dog. In some limited situations, they may be a miniature horse. Examples of what they can do include pulling a wheelchair, providing mobility support, guiding individuals with vision impairment, as well as detecting and alerting individuals of oncoming seizures. That's not an exhaustive list, just some examples of how a service animal can be trained to support someone with a task. Now, for our support animals, by contrast, they are less likely to have special training, but they still serve a valuable function for an individual with a disability. So they can be any type of animal that's commonly kept in a household. So you can see the picture on the screen there, your dogs, cats, birds, turtles, any animal that you may commonly keep in a home. Examples of what they can do include alleviating anxiety, reducing an individual's depression, keeping someone calm and making them feel safe, enabling them to be able to live independently and stably in their home. So they are often helping someone manage a condition that we can't see and is not obvious. So I referenced a memo from HUD earlier, and that states that effective immediately for complaints related to animal-related reasonable accommodations, FHEO, which is Fair Housing and Equal Opportunity, will find reasonable cause and recommend charges only for those cases involving animals trained to provide disability-related assistance. It does not address how the department processes complaints against housing providers under Section 504 of the Rehabilitation Act or the ADA. So it's relatively limited specifically to HUD's fair housing enforcement efforts. So support animals still are covered under our state law. It doesn't change federal law. Uh, it just addresses how HUD is enforcing that law. I also see the note in the chat that ESAs can help individuals maintain their schedule and routine, which is really important for individuals as they're going about their activities of daily living. So thanks for that comment there. I'd also like to note some information about the Assistance and Service Animal Integrity Act of 2018. This is a Pennsylvania law that defines assistance animals in housing settings as including both service and emotional support animals. And it provides clarity around documentation around animals. So this documentation, as we discussed earlier, is only required in situations when the disability is not obvious. Documentation shall be in writing, and it shall be reliable and based on direct knowledge of the person's disability and disability-related need for the animal. Now, I want to pause for a moment here because oftentimes in these discussions, there are questions about these online letter companies that if you do a quick questionnaire, pay a fee, they will give you a letter. And a lot of folks are misled into believing that they need this type of documentation in order to have a support animal. And the reality is that this type of letter does not provide effective, direct knowledge about that person's disability and disability-related need for an animal in the same way that that a note from someone that's receiving care or treatment from a licensed professional. So I would encourage anyone that is trying to get appropriate documentation to talk to your ongoing providers rather than going to these online companies that are seeking to profit off of your need for this animal. Let's see. Documentation should describe the person's disability-related need for the animal. This documentation shouldn't have any specifics about diagnoses, but it should describe what that need is. This act also states that landlords are not liable for injuries caused by assistance or service animals that are permitted by reasonable accommodation requests. So it offers that protection to housing providers. And it also makes it unlawful to falsely represent that an animal is a service or support animal. And there are fines and penalties for that. You can find more information at the link at the bottom of the screen there. All right, let's talk licensure and certification. So under our fair housing laws, there's no specific certification, no licensure that's required to establish that an animal is a service or support animal. In housing settings, there's no need for a vest or special tags. Um, in public settings, oftentimes folks will have a vest or tags on their animal to indicate that this is an animal that's working and shouldn't be disturbed, but this is not needed within someone's home. And of course, there are many fraudulent sites that make people believe that this type of certification or vest is needed when in fact they are not. A housing provider may require that all individuals with animals, whether they are assistance animals or pets, follow state and local regulations, so requiring licensing and vaccinations as applicable. And they do have the ability to issue violations if that animal's conduct violates the rules of the housing provider. It is the individual's responsibility to make sure that their animal is safe and under control. And a housing provider can also hold a tenant responsible if that animal causes physical damage to that housing unit as well. A housing provider is not able to put limits on breeds or impose weight limits on assistance animal requests. So even if there are these limits for other animals on the properties for pets, they do need to be waived for assistance animals. I want to note that a housing provider should be cautious about citing insurance policy as an undue burden. So some insurance companies may increase rates or deny coverage based on specific breeds. So if a housing provider does encounter this situation, encourage them to do their due diligence before doing a denial based on undue burden. So check in, ensure that your insurance company is aware that this is a reasonable accommodation request. Ask for their policy around that. Seek information to see if this coverage is available from other providers before making that denial, just to do their due diligence. And there's more details about that in a memo from FHEO that's linked at the bottom of the screen there. Additionally, a housing provider is not able to pass along additional expenses by charging extra fees, rent, or requiring additional security deposits. So even if those fees, those deposits are required for pets, they do need to be waived for assistance animals. Now with animals, there can be the situation where you have competing disability-related needs. So granting this reasonable accommodation request can impact other residents. So if another resident would voice disability-related concerns uh, to uh, to having an assistance animal on the property, it's important to work through these issues using the interactive process. So an example here is a resident who's requesting an ESA, but another resident discloses that they are allergic to cat dander. Then you need to figure out how you can best accommodate the needs of both residents. And there's a variety of options. If it's a multifamily property, there may be another unit open where one of the individuals could transfer. There may be options in terms of ventilation, air filtration, things like that. But you want to make sure that you're working through this, talking with both residents, ensuring that both concerns are related to a disability that would impact one or more of a person's major life activities, and seeking how you can best accommodate both individuals to the best of your ability. There are resources if you are having trouble navigating the situation. PHRC does have a fair housing line, and that number is on the screen there, 717. You can call our main number, 717-787-4410, or we do have a fair housing line, which I have that number at the end of the presentation as well. You can call, talk with one of our staff members. There's also local fair housing agencies, nonprofits that are dedicated to ensuring fair housing opportunities, and they may be able to help you resolve this as well. I see a question in the chat about whether a housing provider cannot charge a fee for a service animal, and that is correct. There cannot be additional fees that are charged for service animals. So best practices for reasonable accommodation requests, a housing provider should have an established policy on how they are handling reasonable accommodation requests, who's handling them, what the process is, and what that response looks like. It's important to document everything in writing, so that way you've got clear records and your tenant also has clarity around on what was decided. You want to limit the information that you're requesting to just what's needed to process that request. You shouldn't be asking for all sorts of extra documentation, extra requirements, just enough to establish someone's disability and disability-related need for the animal. You want to give that tenant enough time to submit documentation, and you want to make sure that you're also responding back in a timely manner. Of course, paying attention to opportunities to engage in interactive dialogue to make sure that you can meet the needs of your tenant, ensuring that individuals with disabilities have equal access and opportunity to housing. I see a question in the chat. Does the landlord have any rights when it comes to service animals? We did cover some of that content a couple slides back. The landlord can, of course, enforce lease provisions if the animal is violating rules and if there is damage to the property, that landlord can charge that the tenant with the cost of the damage if it's beyond normal wear and tear, because it is the individual's responsibility to control their animal and ensure that they're not causing damage to the property. But if you have a more specific question, please feel free to go ahead and put that in the chat. I do want to briefly cover the complaint process. So if someone believes that they have experienced discrimination in their housing, so if they've been denied an animal unfairly or any other type of housing discrimination, they can contact our agency and they can start by reaching out to either our main number or any of the regional offices to get their complaint started. They can reach out to us via email, go on our website, and we also put out a lot of great information on our social media, but I encourage folks to find other ways to get their complaint started. So either calling, go on our website, or emailing us. They will first connect with our intake team. So they will be asked to fill out a housing questionnaire to provide contact information, what they experienced, and who they're filing it against. They will set up an appointment to talk about this complaint in detail, and the intake team assesses this information to see if this is a situation that PHRC can investigate under our state law. So if this complaint is jurisdictional, if it's timely, the intake team will help them to be able to finalize that complaint, and then the person who is filed against will be notified. Once this complaint is officially filed, it's docketed and served, and it moves into investigation. So both parties are asked to provide information to a neutral investigator who's responsible for investigating if there is a violation of the Pennsylvania Human Relations Act. So an investigator will ask for documents. They may interview witnesses, hold a fact-finding hearing, or seek other ways to obtain evidence. They may go on site or seek other ways of determining the evidence of the situation. We have a stellar mediation team, and mediation services may be an option depending on the facts of the case and depending if both parties agree to mediation. That can help the complaint to be resolved quickly, flexibly, and confidentially. But if mediation isn't elected, the investigator will continue investigating, and they will also explore if it's possible to settle the case before coming to a finding. If the case does proceed to a finding, there's two possible outcomes. So there's probable cause, which means that there was enough evidence discovered to determine that discrimination occurred. If probable cause is found, then that case may be conciliated. It may advance to a public hearing in front of one of our hearing examiners or commissioners, or it may be filed in court. So at this point, our agency shifts. We're no longer neutral. So at this point, our goal is to seek a remedy because we've found this evidence of discrimination. If no probable cause is found, that's pretty much the end of the line. If someone believes that this determination is not correct, was unfair, they can file an appeal. But other than that, the case is closed. The amount of time that it takes to investigate a case really varies based on the evidence of the case, based on how quickly both parties respond, as well as other factors. There are some remedies that can be achieved in housing cases. So some folks will say, well, why would I file this complaint, go through all of this process? But there are some things that can be achieved. So that reasonable accommodation or modification can be made. Someone can be allowed to have that animal in their housing if that was the situation that was filed against about. If there's discriminatory clauses or terms in the lease or in other policies, we can require those changes for that housing provider, ensuring that all tenants of that housing provider have fair policies. There may be required posting of fair housing notices. In most cases, we require training for respondents to ensure that they have full knowledge of their fair housing responsibilities and are able to comply with our fair housing laws going forward. And there can also be financial remedies as well. So anything from reimbursement of fees and out-of-pocket expenses. So say someone was charged pet fees for an assistance animal, those may be reimbursed. There may be money for humiliation and embarrassment, which is similar to pain and suffering, acknowledging the impact of that discrimination and what it meant for that person's daily life, as well as civil penalties. If it advances to a public hearing, it can be up to $10,000 per count. To give a couple examples of some recent awards, you can see our largest award here, 1.5 million. This is a housing provider that failed to provide accessible units. It ignored requests for reasonable accommodations for tenants with disabilities. There was a $100,000 case where a maintenance worker sexually harassed a female tenant, a $90,000 case where a housing provider revoked a lease and failed to address neighbor harassment based on race, as well as a $77,000 case where a housing provider made discriminatory statements and refused to rent to a household based on their familial status. I do see some questions in the chat, and I will get to them in just a moment. But I want to just highlight a few fair housing resources. First, we do have free housing training programs. If you're interested, we can offer those virtually or in person. You can get more information about that on our website. We have this ongoing series, our Fair Housing and Power Hour series. Next month, we're going to be focusing on the issue of appraisal bias, and we'll have Andy Toy from the City of Philadelphia coming to talk with us about that. Our August session is going to be hosted by Dr. Julie Wilson, who's talking about Common Roots and their community land trust in Meadville, Pennsylvania, and the success that they've had in addressing community housing needs there. We offer brochures and fact sheets. You can get digital versions from our website or request us to mail some out to you. We're happy to share those resources. We aired a show on PCN TV called PHRC Speaks, Fair Housing Forward, and we've got a great archive of past episodes on our YouTube channel. We also have a report called The State of Fair Housing in the Commonwealth of Pennsylvania. That's PHRC's white paper, looking at the barriers that are keeping folks out of access and opportunity to housing, provide some policy recommendations, and it's a great read if you've got some time. We offer a quarterly fair housing e-newsletter, so please feel free to email me if you'd like to just stay in the loop with fair housing news and resources and events. And then the fair housing line that I mentioned earlier is 855-866-5718. And here's my contact information if you have any questions or concerns following this presentation today. So I wanted to go back to the chat to answer the questions that are raised here and encourage anyone else that has remaining questions to put them in the chat as well. So a question is, an animal cannot be denied if the landlord simply doesn't want animals in their building, and that is correct. An animal cannot deny an assistance animal. They can deny a pet if the landlord does not want animals in their building, but they cannot deny an assistance animal unless there is a specific health and safety reason or an undue burden. All right. Our next question is, can a potential landlord or a property managed company ask in a lease pre-screening process if they have an ESA? So if this is in an application, That could be an issue because that could be a discriminatory inquiry. So, David, please feel free to reach out to me if there's a specific situation that you want to inquire about. But I would be concerned if there would be questions about someone's disability-related need for an animal as they're being assessed as a candidate for housing. I will send out copies of these slides to everyone who attended today and anyone who registered. I will also send out the recording for future viewing as well. All right, and I think there may have been a question in Q&A as well, so I'm going to check that now. The question in the Q&A is about medical marijuana. Are they considered currently using illegal drugs and exempted from disability-related protections? Because this is the federally controlled substance, they would be exempted disability-related protections, and a housing provider would not be required to make that reasonable accommodation to allow someone to smoke medical marijuana in their unit. I think I have gotten to all the questions, but I encourage anyone else that has remaining questions about assistance animals, about reasonable accommodations, or other areas of fair housing protections to feel free to put any questions in the chat or raise your hand if you have any questions. And while I'm waiting for any additional questions to come in, I'd like to thank everyone for your time and attention and participation today. I see the question about the change in class. I would need to do some additional research, and I'd be happy to get back to you about that one. All right, I am going to go ahead and close this out. So thank you all, and I hope you enjoy the rest of your day. Lydia, let me unmute you so that way you're able to ask your question. All right, Lydia, you should be able to unmute at this point.
Okay, thank you. I have a question. As far as the common areas, for instance, for senior properties, service animals have to be allowed in the shared spaces, but not emotional support animals. Is that correct?
A housing provider should seek to accommodate support animals unless there is a specific health and safety reason uh, that would prohibit them from being in common areas.
Okay, thank you.
Absolutely. All right. Well, thank you, everyone. Have a great day.